Hey there, everyone. It's Rob Ryder. September 6th, 2015. That would be a Sunday. And we are going to today talk about the special grand juries, which you will find in 18 USC 3332. Actually, from about 3331 to 3335. But this is the powers and duties, and this is the meat and potatoes that I want to build on. And we'll see what happens. But this is what it says. It says it shall be the duty of each grand jury impaneled within any judicial district to inquire into offenses against the criminal laws of the United States alleged to have been committed within that district. It's their duty to inquire into alleged offenses. Well, then we should tell them about some. Well, such alleged offenses may be brought to the attention of the grand jury by the court, and the court would be the grand jury members, or by any attorney appearing on behalf of the United States for the presentation of evidence. Any attorney appearing on behalf of the United States. Well, who would they be? They would be any attorney that took an oath that has the words that they're going to abide by the laws of the Constitution of the United States. We'll look at the words here in a minute. But, any attorney who's taken an oath that has anything to do with the United States is an attorney representing the United States for the presentation of evidence. Any such attorney receiving information concerning such alleged offense from any other person, that would be me and you, shall, if requested, and I shall request by such other person, that would be me, inform the grand jury of the alleged offenses, the identity of such other person, and such attorney's action or recommendation. So the attorney doesn't have a choice. He has to give it to the special grand jury. And they make a point in something we're going to see that, these are special grand juries. They're not the normal grand jury. I don't know what that means. It's what they're talking about. But what it does say is if you allege a violation of a criminal law of the United States to this attorney and ask him to give it to the grand jury, the special grand jury, established under 18 USC 3331, or whatever the number is, that he has to do it. And if he doesn't, well, that would be, like obstruction of justice. And hey, they got stuff for that too. Right? In fact, if we were to look at the Cornell site, Obstruction of Justice, it's got its own chapter in, 1501 all the way down to 1521. Got lots of things that are considered obstruction of justice. Well, that attorney not taking it, to me, is going to be in one of those, so I'm just going to say he's obstructing justice and let somebody else figure it out. But continuing on. So here's one of them. Whoever, by threats or force, willfully prevents, obstructs, impedes, or interferes with, or willfully attempts to prevent, obstruct, impede, or interfere with the due exercise of rights and performance of duties under any order, judgment, or decree of a court of the United States shall be fined under this title or imprisoned not more than 1 year or both. Well, this law itself is an order from the court because it came out of Congress, and the courts of legislature are the highest courts in the land. They're the ones that can make a law or rescind a law. The other courts can just enforce them and define them, I guess, to make sure that they're, I don't know if that's the proper word to use. But my point is, Congress is a court. Congress decreed, and it was codified as 18 USC 1509, what obstruction of justice is. Okay, so not following 18 USC 3332, which is an order from a court, that court being Congress, would be obstruction of justice. Obstruction of a criminal investigation. Whoever willfully endeavors by means of bribery to obstruct, delay, or prevent the communications of information relating to the violation of any criminal statute of the United States by any person to a criminal investigator shall be fined under this title or imprisoned not more than 5 years or both. Willfully endeavors by means of bribery. Now, I don't know what bribery definition is, but I don't think it would have to be just necessarily to do with money. Okay, so my point is, right, that according to this, 3332, if you allege criminal activity, it has to go to the grand jury. And in the Constitution, I got it here someplace, I believe it's in the Bill of Rights, number 5, right? You cannot be held to answer to an infamous crime unless it's from an indictment from the grand jury. Well, to answer to anything means to appear for the first time, right? So you have to take it to the grand jury. They have to get an indictment, and then the people come to court. You can't bring somebody to court under a criminal matter because it can only be done by a grand jury. That's what the Constitution says. And since you're pointing out crimes, only the state can prosecute for a crime. Even if you believe that you are a private attorney general, you're not doing it in your name, you still need to do it in the name of the United States. Only the government can prosecute for a crime. I think you're being the attorney general by taking it to this guy and having him take it to the grand jury, because that's what the attorney general has to do, or the U.S. attorney. They have to take it to the grand jury to get an indictment. That's the first step. Need to get the indictment. Our avenue to get an indictment is to write it and give it to an attorney and say, go give it to the grand jury. Impaneling. This is found on the U.S. attorney site. I have to remember. Anyways, if you put it in paneling special grand juries into Google, you'll find there's a whole bunch of things written on this. But as provided in 3331, a district court in every judicial district having more than 4 million inhabitants must impanel a grand jury at least once every 18 months. And the district court must impanel a grand jury when the attorney general, blah, 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 because criminal activity in the district. Just because of that. So we need to point some out to them. District courts are authorized to impanel additional special grand juries when the special grand juries already impaneled have more business than they can handle. So we can have as many as we want. If we start ramping it up, they'll just keep impaneling juries. When impaneling additional special grand juries, the court should make a finding as to the need, and the court should always make it clear the special grand jury is being impaneled under 18 U.S.C. 3331 and is therefore not subject to the limitations of a regular grand jury. There's something special about it. It's not limited. The special grand jury has a duty to inquire into offenses against the criminal laws of the United States alleged to have been committed within that district. Such alleged offense may be brought to the jury's attention by a court by attorney appearing in the United States to present the evidence to the jury. It is incumbent upon every government attorney to whom it is reported that a federal offense has been committed within the district, if the source of information so requests, to refer the information to the special grand jury. Naming the source and apprising the jury of the attorney's action or recommendation regarding this matter. Well, any attorney who's licensed to practice law is an officer. They're a civil officer. The oath they take made them an officer of the court. So they're all government attorneys. Report to the special grand jury. At the conclusion of the service, a special grand jury is authorized under 3333 by a majority vote of its members to submit to the district potentially for public release a grand jury report which concerns either non-criminal misconduct, misfeasances office involving organized criminal activity by appointed public officer or employee as the basis for recommendation of removal or disciplinary action, or organized crime conditions in the district without, however, being critical of an identified person. And public officer or employee is defined broadly to include federal, state, local officials. They're all lumped into one, and we can get them for non-criminal misconduct, misfeasance, whatever that is, because they're the ones that are involved in this. So, for instance, I have an ongoing issue with Consumers Energy, which says it's a utility, but it's not, and I took it to the Michigan Public Service Commission to have them do something with it, and they didn't do a thing. So that's malfeasance, misfeasance, non-criminal misconduct. I'm just going to say it's fraud. Let's go for it all. Put a complaint in and, let the grand jury figure it out. They're supposed to investigate it. I just need to allege somebody broke the law. Be doing my civil duty. Upon receiving a report from a grand jury, the district court must examine it together with the minutes of the grand jury, of the special grand jury, accept it for eventual filing as a public record. If the report is one or two types authorized, based on facts, I got things I want you to do. I don't want to read too much about that. But the misconduct, malfeasance, misfeasance that may be subject of a report must, to some degree, involve willful wrongdoing, as distinguished from mere inaction or lack of diligence on the part of the public official. Nonfeasance in office, however, if it is such serious dimensions as to be equitable with misconduct, may be a basis for special grand jury report. I don't know what nonfeasance is, but I'm going to say, I'm going to use that one because they use the word equity. And so, dereliction of duty from these officers in the state of Michigan, as far as their regulatory affairs are concerned with the presumed public utility that doesn't have the credentials a public utility is supposed to have filed with the Secretary of State or have their rate book filed with the Public Service Commission or any of these things. Okay, well then it's nonfeasance. And I want an equitable remedy for their nonfeasance because they were supposed to get me they were supposed to give me my remedy and they haven't done it. Reports involving public officials must connect misconduct, malfeasance, or misfeasance with organized criminal activity. Organized criminal activity should be interpreted as being much broader than organized crime. It includes any criminal activity collectively taken. Two or more people involved made it a conspiracy. More about the reports, which you can all read on your own some other time. More on the reports. This is actually the law. Talks about it. But you get the idea, right? First of all, going back to the beginning, let's start at the beginning. As simply as you can, point out all you need you only need one. We don't need 20. We just need one thing that's done incorrectly to be considered a crime. And tell an attorney you want them to bring it to the attention of the special grand jury and show them this law and say, you have a duty to do this. If you don't do it, well, then that would be obstruction of justice. You're obstructing a court order from the parliamentary court known as the Congress. These are the Congress's orders. 18 U.S.C. 1509 is a congressional order. So is 18 U.S.C. 3332. Okay. Where to from there? So, for instance, let me go to oath of office real quick. Who's doing what? First of all, what's faithfully mean? Because that's the word they like to use in the oaths. In a faithful manner, with good faith, with strict adherence to allegiance and duty, with strict observance of promises, vows, covenants, and duties. Right? Never uses the word God, but faithfully, good faith means, well, what does faith mean? Right? Do what you say you're going to do. If you don't do it, well, then you broke your oath. An individual, except the president, now this is in 5 U.S.C. subsection 3331, oath of office, an individual, except the president, elected or appointed to an office of honor or profit in the civil service or uniformed services shall take the following oath. I, A.B., do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear truth, faith, and allegiance to the same, and I take this obligation freely without any mental reservation or purpose of evasion, and I will well and faithfully discharge the duties of office which I am about to enter. So help me God. This section does not affect other oaths required by law. So they have to take, people that are taking any office of honor or profit. And what would honor? Well, when they're called you're honorable, I would say they've taken this oath. And they have a duty to defend the Constitution. And the Constitution is a thing that says, You need to, you now, because you're defending the Constitution, well, you need to enforce the criminal laws of the Union. Now, why is all that important? That's a good question. I don't think I'm quite ready to go there yet. Let's go to this. So, here's the same oath. Now, this is off the Senate's website, but here's a little history on it. At the start of each new Congress in January, every odd-numbered year, the entire House of Representatives, one-third of the Senate, performs a solemn and festive constitutional rite that's as old as the Republic. When the oath-taking date to the first Congress, 1789, the current oath is a product of the 1860s, drafted by Civil War-era Congress, intent on ensnaring traitors. Well, let's go, the oath is set up to ensnare traitors. They've already done it. They are already ensnared. We just need to go and collect their pelts. The Constitution contains an oath of office for only the President. So the one in the Constitution is only for the President. For other officials, including members of Congress, the document specifies only that they shall be bound by oath or affirmation to support this Constitution. The first Congress reworked the requirements into a simple 14-word oath. I do solemnly swear or affirm that I will support the Constitution of the United States. That's all there was to start with. And that was good for 3/4 of a century, and then they changed it, added some words, did their things. During the war, they went to a test oath, inspired into law, or signed into law July 2nd, 1862, requiring every person elected or appointed to any office under the government of the United States, excepting the President of the United States, to swear and affirm that they never previously engaged in criminal or disloyal conduct. Those government employees who failed to take the test would not receive salary, and those who swore falsely would be prosecuted for perjury and forever denied federal employment. Although the Congress did not extend coverage of the ironclad test oath to its own members, go figure, many took it voluntarily. Oh, we're going to make other people take it, but not us. That's your Congress working for you. And we plan on being involved in traitorous stuff. So the way it is today, actually none of these people have taken the proper oath. I've already done numerous videos on this. This is just saying what they're supposed to do. The 1868 public law prescribed this alternative oath for any person who would participate in a late rebellion and from whom all legal disabilities arising therefrom had been removed by act of Congress. So, anyways, the Senate then revised its rules to require a member not only take the test oath orally, but also that they subscribe to it by signing a printed copy. This condition reflected the wartime practice in which military and civilian authorities required anyone wishing to do business with the federal government to sign a copy of the test oath. I wonder if that's what we're supposed to do right now and go give it to the district court. Right? Go sign a copy of the test oath. What else are they talking about? This one right here. The one that's in 5 USC. So, that's the test oath. Okay. And that's how that all works. There it is again. Now, what does all that got to do with? Okay, well, now let's get down to looking at some other things about oaths. First of all, this is for the Grand Rapids Bar Association. And if you want to be a member of this bar association, it says this: after bar exam results are available, the Grand Rapids Bar Association will send a letter to all the admittees who submitted a mailing address in Kent County to the Board of Examiners. If you did not submit a mailing address in Kent County to the Board of Examiners, but you would like to participate in the Grand Rapids Bar Association ceremony, please call some number. So it sounds like if you had a mailing address in Kent County and you went and did the bar exam and, filled out their paperwork, that if your address was in Kent County, you were going to get a announcement to come down for a swearing-in ceremony. The letter sent out by the Grand Rapids Bar Association will describe the items you must provide in order to participate in the admission ceremony. They are the name of your sponsoring attorney, the name you would like to appear on your certificate of admission, the original notice you received from the bar examiners, a check for $25 to the Kent County Clerk. In Kent County, that would be the political subdivision of the state of Michigan, not the County of Kent, which is a corporate body politic. And then a check for $175 payable to the U.S. District Court. Well, why are they making a check out to the U.S. District Court? The petition for admission for which you receive in this letter, which you will bring with you to the ceremony. Everything else must be delivered, deadline, yada, yada, yada. Okay. Well, they have something to do with, where did it go? You will proceed, okay, so, now this is an independent administration. Let's say you don't go to the swearing in. Well, this is how else it's going to happen. On the date of your ceremony, please come to Suite 2400, ask for Alyssa with the following items. And Alyssa is in the Kent County, Michigan government. So I'm going to have to write Alyssa and see if she has the role of attorney, because that's what we're going to look at here. Bring your stuff. You will proceed to the judge's courtroom to be sworn in after this. Once this has been done, you will return to the clerk's office to sign the roll of attorneys. So there you go, right? And so now they're going to have to subscribe the roll of attorneys. I believe that's going to be them saying that they subscribe the oath. That's part of doing the roll of attorneys. Once this is done, you will return to the clerk's office. What clerk's office? Well, the one in Suite 2400. Ask for Alyssa. She must be the one that has the roll of attorneys. I'm going to email her this weekend. So that's locally, but it also says admission to the Eastern District for Michigan, application for admission, original certificate of good standing issued in the last 30 days from the court of record identified in the application. This must be from the court, not from the bar. A written statement of facts disclosing the previous disciplinary issues, application. I find this interesting. See, they call it the U.S. District Court, right? Normally you see the paperwork that says U.S. District Court for the Eastern District of Michigan or U.S. District Court, Eastern District of Michigan. But this says Eastern District of Michigan, United States District Court. And the address just says U.S. District Court, Clerk's Office. Right? It doesn't say the Eastern District. So, this is the wordplay stuff they do. And, well, this is the U.S. District Court. That's the court we want to deal with, in my opinion. They're the ones that would impanel the grand jury. Complete a declaration of sponsor if receiving the oath of office remotely, a signed oath of office form, a copy, and I haven't been able to find the form yet. I wish I could. A copy of the email received from the court indicating the attorney is now eligible to receive the oath of office. Got to sign the damn form and go do what they're supposed to do. The oath of office may be administered either in person or by telephone or video conference. In person, applicant that reside within the Eastern District of Michigan must take the oath of office in person. Applicants will provide the oath of office form to the judicial officer. After the oath is administered, the oath of office form must be signed by both the applicant and the judicial officer conducting the oath. The judicial officer will return the oath to the clerk's office. Okay, so anybody who's done this, right, if they're on the roll of attorneys in the U.S. District Court, then they're an attorney who represents the United States. So if nothing else, we need to find one of them. But the way the rule said, it said any attorney. And at some point, they're all going to take an oath that has something to do with the United States. Where was that one? Here's one for California. Where is that thing? All right, this is what... hang on a second. The attorney's oath for California. I don't know what this said at the top of the page. What am I looking at? Business and Professional Code, Section 6068, Duties of Attorney. I solemnly swear that I will support the Constitution of the United States. Stop. Don't need to go any further. They have all taken an oath to the Constitution of the United States. It's first. Their first duty is to the Constitution of the United States and the Constitution of the State of California, and faithfully discharge the duties of an attorney and counselor at law to the best of my knowledge and ability. Good enough. Got the word faithfully in it, and it's to the Constitution of the United States. It's first, and when you do a little research on this, you'll find out that in the oath, because it says Constitution of the United States first, that's their first duty. So they are all attorneys representing the United States. All right, that's what I'm going to stick with. I'm going to, that's what I believe. So one of the things I did, and this is the reason I did it, is this has to do with Planned Parenthood that I've already put a complaint in on, but here's why I did. And so this would apply to any 501c3, not just Planned Parenthood. And so there's plenty of low-hanging fruit for others that would like to do something besides bitch about it, to do it by bitching about it and giving it to an attorney and telling him to give it to the grand jury. Because it says, this is off the IRS website, under the Internal Revenue Code, all Section 501c3 organizations are absolutely, I believe that would be completely prohibited from directly or indirectly participating in or intervening in any political campaign on behalf or in opposition to any candidate for elective public office. Contributions to political campaign funds or public statements of position, verbal or written, made on behalf of an organization in favor of the opposition to any candidate for public office clearly violates the prohibition against political campaign activity. It's verboten. They can't do it. And Planned Parenthood, they're up to their neck in political contributions. Hillary Clinton's their biggest recipient. Violating this prohibition may result in denial or revocation of tax-exempt status and an imposition of certain excise taxes. So from the moment you violated it, ipso facto, you just lost your tax-exempt status. And if you didn't pay taxes, well, then you're a tax evader. But it goes on to say, so now here's the law. It's 2 U.S.C. 44. Is it 441B or 2 U.S.C. 44? I don't think it's 3 B's. I may have done this wrong. I better go. I don't want to tell you incorrect. It's maybe 441. Give me a second. I'm almost positive. Yeah, I had one too many in there. Right. It's 2 U.S.C. 441B. And it said, there. Now, funny thing is, since I did a complaint about probably going 3-4 weeks ago, the first time I tried it, they've added these notes where they've editorially moved it to 52 U.S.C. 30118. So I don't know what it means to editorially move something, but I don't think it means to lawfully move it, so it's still 2 U.S.C. 441B. They're just trying to hide it now, because it says in there, contributions or expenditures by national banks, corporation, or labor organizations. In general, it is unlawful for any national bank or any corporation organized by authority of any law of the Congress to make contributions or expenditures in connection with any election to any political office. Period. Don't need to go any further. All I need to know is, well, did Planned Parenthood, which is a 501c, would be a corporation organized by the authority of the Congress, because the Congress is responsible for the U.S. Code, right? That's their rules. That's their decrees. That's what the legislative court has decreed. But on top of that, then, in 26 USC 7201, attempt to evade or defeat taxes. Any person who willfully attempts in any manner to evade or defeat any tax imposed by this title or the payment thereof shall, in addition to other penalties provided by law, be guilty of a felony. Under conviction, upon conviction, shall be fined no more than 100,000, 500,000 if it's a corporation, imprisoned no more than 5 years, or both, and so forth. So these are definitely infamous crimes, and that's why it needs to go to the grand jury first, because you have to have an indictment. And 18 U.S.C. 101, false statements. Except as otherwise provided in this section, whoever in any manner within the jurisdiction of the executive, legislative, and judicial branch of the government of the United States knowingly or willfully falsifies, conceals, or covers up by trick, scheme, device a material fact. In other words, an omission of a material fact is a crime. Not telling you something that's you have a material interest in is a crime. Makes any false, fictitious, fraudulent statement or representation, such as representing to be an attorney using a false name, fictitious name, or makes or uses any false writing or document knowing the same to contain any material, false, fictitious, fraudulent statement or entry, shall be fined under this title and imprisoned not more than 5 years. Boom, boom, boom. All right, so with those 3 laws, you should be able to shut down any 501c3 that you find that's involved in campaign finance contributions. And if you go to the Federal Election Committee, I think is what it is, Federal Election Committee, campaign, can't remember what they call it exactly. That's where they keep track of everybody who gives campaign contributions. And on there you'll find all sorts of stuff about Planned Parenthood. No question they do it. So, okay, so what did I do with all that? Not quite ready for that one yet. What I had done first was I had sent this bill of information to the grand jury of the U.S. District Court. But this one's in Grand Rapids, Michigan. And as you can see, it was received August 20th, 2015 at 10:20 a.m. by Tracy Cordes, Clerk, U.S. District Court, Western District of Michigan. I, Robert Allen Radlewski, one of the people of the United States, representing the same, by this information informed the court of infamous crimes committed against the laws of the United States. When I first did this, I said, okay, I'm an attorney of the United States. I'm going to represent the United States. I just said I am. I'm an attorney. I'm not an attorney at law, but it didn't say you had to be one. It just said you need to give it to an attorney. And if somebody gives you power of attorney, well, that just made you an attorney. So I just said I am one. I'll go ahead and do it this way. And I pointed out the 3 laws, and Planned Parenthood Federation of America, with their address, directly or indirectly engages in campaign contributions in violation of 2 U.S.C. 441B, extinguishing their presumed tax-exempt status as that of a public charity, and rendering their IRS Form 990 as a false statement used in an attempt to evade taxes. Planned Parenthood Federation of America, Inc., that's their EIN number, directly controls Planned Parenthood Action Fund, Inc., which they do, which has its own EIN number, and others indirectly as noted on Schedule R, which is one of the forms that's attached to their 990. So you go find the 501c3 corporation's 990 form, which they're supposed to make publicly available, and you go to something like Schedule R, and it will show you all the other entities that they're directly or indirectly involved in. And with all them names, you go to the Federal Election Commission's site to see if any of them are involved in campaign financing. And if they are, well, you can shut down the 501c3. The Federal Election Commission has recorded PPFA, Planned Parenthood Federation of America, wrongdoing over many years, thus or through Planned Parenthood Action Fund, available by searching this ID, which is this committee. See, so Planned Parenthood Action Fund is actually a committee. They got a committee ID. They're involved so much. They got their own number. And if you go search that number, you'll find all sorts of stuff that have to do with Planned Parenthood. Well, then they're involved in campaign financing. I don't need any more. But this is what I got back. I got an order. So I sent it, first of all, I sent it to the U.S. District Court. I got an answer from the United States District Court, Western District of Michigan, Southern Division. To my all caps, order rejecting pleading. The court has examined the following documents received and orders the clerk to reject the criminal complaint and return the documents to me. They put my name in proper case. Good for them. For the reasons noted below. I'm attempting to file a criminal complaint. Duh. Yes. A criminal complaint may be initiated only by a United States Attorney's Office and not by an individual. You are incorrect, Ray Kent. It is so ordered by somebody named Ray Kent, who says he's a U.S. magistrate judge. And as it turns out here just recently, a guy they call Ray Kent was made a magistrate judge. But there are no attorneys named Ray Kent, and to be a magistrate judge, you got to be an attorney licensed to practice law within the state, so this guy is not really anybody I care to do business with. Well, that's what he said, and so I said, well, what am I going to say back? You know, jeepers, what am I going to do? So this is what I did. I did this on September 4th, 2015, to Tracy Cordis, clerk of the court. I just took her information, all something I found, yada, yada, yada. Clerk of the court, Cordis, I have attached a copy of a simulated legal process, which was the order rejecting the pleading that we just read, that was sent using the mails. That would be fraud and swindles as far as I'm concerned, but I'm not here to point that stuff out. Within which an individual calling himself Ray Kent is claiming to have some non-existent authority in a common law criminal matter. Ray Kent is the assumed name of a licensed attorney, Raymond S. Kent, most recently associated with the Federal Public Defender, Western District of Michigan office. That's who he was until just a little bit ago he was made a magistrate judge. Appointed one. The United States District Court, Western District of Michigan, is not an Article III court and has no jurisdiction in a criminal matter. However, in his office of attorney and counselor at law, Raymond S. Kent, P44156, has a duty as a public officer to forward my complaint to the grand jury. Maybe I should have put special grand jury. I think I would do that next time. Always use special grand jury in accordance with 18 U.S.C. 3331. To not do so would be a violation of 18 U.S.C. 3332A, which says, it shall be the duty of each grand jury impaneled within any judicial district to inquire into offenses against criminal laws in the United States alleged to have been committed within that district. Such alleged offenses may be brought to the attention of the grand jury by the court or by any attorney appearing on behalf of the United States for the presentation of evidence. Not to prosecute it, to provide evidence. Any such attorney receiving information concerning such an alleged offense from any other person, if requested by such person, inform the grand jury of such alleged offense, the identity of such person, and such attorney action or recommendation. So this, again, is where you do your affidavit, and you go to this civil law notary, who's actually what we would call an attorney, and he subscribes, he witnesses your signature on your affidavit. And because he's a civil law style notary, all of his things that he subscribes his name to are given full faith and credit. He can authenticate for the state. His signature is an authentication from the state when it's done properly. And so you take it to him, and you subscribe it before him, and you make him witness your subscription, and now he has a duty to get it to the district or to the grand jury. If he doesn't, well, that would be obstruction of justice. So anyways, I wish you, Clerk of Courts Cordis, inform Attorney Raymond S. Kent, P44156, to inform the grand jury of the alleged offenses already on file with the court regarding the unlawful activity of Planned Parenthood Federation of America. Ray may have violated any number of laws, and I leave it to the court's judgment on how best to serve justice in this manner. The clerk of court is also a public officer with duties under common law, like enforcing the laws of the United States and prosecuting breaches of the peace, such as trespass on the case. Should Attorney Raymond S. Kent, P44156, be unable or unwilling to execute his fiduciary duties and deliver said information to the grand jury for their investigation into the facts, then I order the clerk of the court to execute the law and have Attorney Raymond S. Kent, P44156, arrested, and for the clerk of the court to deliver the information to the grand jury on behalf of the court. That's what I had to say. Got it all on one page. I had to squeeze it a bit, but okay, good enough. All right, now I did it this way in this case because they already had it. An attorney sent it back to me, claiming to be a judge under an assumed name, and I don't give a shit about that. What I do know is under this name, Raymond S. Kent, P44156, he claims to be an attorney, and therefore I'm asking him to give it to the grand jury. I'm asking the clerk to tell Raymond to give it to the grand jury, and if Raymond won't do it, well then throw his ass in jail and you do it. And I sent that on the 4th, right late in the afternoon. So, we'll see what happens this week. See if there's any news to be heard. But what I'm going to do next is, in one of my earlier videos, I had put a complaint in to the probate court, trying to get them to, give me a remedy in equity, and it doesn't seem to have worked because it's the county of Kent, not Kent County. Right? And the county of Kent is a corporate body politic, little black hole where nothing ever leaves. Things may come in, but it never leaves, right? They get you inside there. They don't want you to leave. And but I'm gonna do something like this. Right? These are the facts I'm going to use. This has to do with my Consumers Energy, which is the supposed, this is for everybody now, whoever your utility is not a utility. So I'm going to give them some adjudicative facts, evidentiary facts, like it pointed out in the video I did just prior to this one. Right? You need to have evidentiary facts. Well, there'll be evidence facts just as soon as the frickin' attorney signs his name to it and gives it to the grand jury. Well, that'll be evidence. Because that's what the law said he's there for, is to give evidence. So this is what it says. See, I wanted the court to take judicial notice that due to mistakes in the official records, my proper person, complainant, is the victim of an enforced disappearance from the civil records, requiring my seeking the court's protection of my physical person and estate under Estates and Protected Individuals Code. Because when you go to court, your name is backwards. Well, that gave me a civil disability because I'm not Robert Allen Rutluski. And right, I needed to be represented. Well, if I need to be represented, then I need to be protected under the provisions of law for estates and protected individuals. That's all probate stuff. I'm not using this again. I'm just saying what it said at the time. But here's the adjudicated facts. Consumers Energy, hereafter respondent, has never signed a contract with complainant or a personal representative of complainant's estate regarding account number, and that's the account number on the account. Complainant alleges respondent is not a utility and has no legal standing. And there's a court rule that goes with that. Corporate entity documents available online from the Michigan Department of Licensing and Regulatory Affairs attest that the respondent is an assumed name of Consumers Power Company of Michigan. That's the ID number for the Consumers Power Company of Michigan. An entity allegedly incorporated by a sole incorporator named Consumers Power Company of Maine. So Consumers Power Company of Maine came to Michigan and they were going to incorporate another company called the Consumers Power Company of Michigan. However, Consumers Power Company of Maine did not acquire a certificate of authority as mandated by Michigan corporate law for a foreign corporation to obtain, thus ensuring Consumers Power Company of Michigan and all other assumed names to be void of legal capacity. The incorporator, the incorporator, Consumers Power Company of Maine, didn't follow the frickin' rules to incorporate a company called Consumers Power Company of Michigan. Yep, the paper's there, but they didn't get a certificate of authority first to do it. They just submitted the papers. And apparently the state didn't catch it. Whoops. Is that malfeasance? Nonfeasance? What kind of feasance is that? Somebody's head needs to roll. Respondent refuses to identify the creditor and validate alleged debt owed, contrary to Federal Trade Commission Fair Debt Collection Practices Act and 1988 PA Regulation on Collection Practices. That's the state law, the PA 70, but the Federal Trade Commission has a Fair Debt Collection Practices Act, and it says if you're not the original creditor and then you're a debt collector, and as the debt collector has to validate the debt and say who the original creditor was, and they won't do it. Respondent, again, Consumers Energy, claims to be regulated by Michigan Public Service Commission, but no rate book is filed in that name. A rate book for Consumers Energy Company is filed, but its contents are contrary to requirements of Michigan Administrative Code, blah, 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 without tariff sheets, franchises with political subdivisions, and commission stamps of acceptance. Further, the Constitution, Article 7, subsection 29, mandates utilities acquire a franchise from the township. It's a constitutional requirement that any utility have a franchise with the township. And they don't. On June 5th, 2015, Jason M. Milestone, representing Consumers Energy under its legal department, used the mails to deliver a simulated legal correspondence disputing any obligation to verify debts mandated by FTC, Fair Debt Collection Practices Act, nor any obligation to provide a copy of the franchise required by Constitution. Jason subscribed this instrument using a fictitious name while in his official capacity. Complainant believes this is a violation of Michigan rules of professional conduct and in direct contempt of the Supreme Court. All legal department attorneys listed on correspondence attached to Exhibit 1 are using fictitious names in place of their legal name, certified yearly with the State Bar of Michigan in their official capacity. On June 22nd, complaint received a correspondence from respondent's representative, Randy Richards, customer care representative, attesting respondent's refusal to provide certificate of good standing for Consumers Energy unless ordered by court subpoena. Exhibit 2 also alleges complainant's inclusion of some internal report that threats of violence with no due process, slandering my God-given character. And statement of claim for relief. Enduring the above-mentioned civil disability compels me to demand declaratory judgment from the court of probate, People's Conservator, in favor of the people, yada, yada, yada. So I don't know how much more of this part I'm going to use, but, these are the adjudicative facts, right? Simple statements of fact that they can either be yes or no to. Yes or no, yes or no, yes or no. It's simple as that. And that was just extra stuff I didn't really use. So I'm going to try that next with them and see where that leads me to. But I guess the big thing was to point out just the what is what it is. So what is it? It is... How come I can never just put my hands on it? that the one? I guess I'll open them all before I'm done. Special grand juries, 18 U.S. Code 3332, powers and duties. It shall be the duty of each grand jury impaneled within any judicial district to inquire into offenses against the criminal laws of the United States alleged to have been committed within that district. They have a duty. If you don't allow them to do their duty, then you're obstructing justice. Right? So, such alleged offenses may be brought to the attention of the grand jury by the court or by an attorney appearing on behalf of the United States for the presentation of evidence. That's all they're going there for, is to give them some evidence. Because the grand jury we're talking about, this isn't what happens in court. This is just to get an indictment, to get whoever it is to answer to the charge. Without the indictment, they don't have to answer. We have to get the indictment, and you can only get an indictment from a grand jury. So, this law has to be used. Any such attorney receiving information concerning such an alleged offense from any other person shall, if requested by such other person, inform the grand jury of such alleged offenses and identify the identity of such other person and such attorney's action or recommendation. So write it up as an affidavit, subscribe it before the attorney. He's got to put his subscription stuff on there. It just became a self-authenticated public record. It stands as the truth till it's rebutted, and now it goes to the grand jury and they say, okay, we got this. Let's get an indictment, and we'll have the other guy answer to it. And then they decide if they're going to have a trial or not. But we're a long way from the trial. This is just to get an indictment to have somebody have to answer to it. Right? It's like the warrant. This is the warrant, in my opinion, under the Constitution, to have somebody arrested for not appearing. Otherwise, they don't have to appear. I know that isn't what they do to you, but you're not dealing with the true sovereign government. You're dealing with the corporate body politic, and this is what we're going to shut down by going and saying, hey, they're not following the law. Hey, they're not following the election law. None of these people are elected. Right? Here's an example. This is why I say this, right? Well, because they don't have a certificate of election from the governor like the election law says they're supposed to. So all you need to do is go read a few sections in your election law about what somebody's supposed to do to fulfill the duties of the office, and eventually the last thing they need to do is get a certificate of election. Well, probably the one just before that is where the state's election authority is supposed to certify that they were the winner. And that hasn't been done, which means the state election board hasn't done their duty. And how are you going to find out? Well, they're going to have the grand jury can subpoena the records. We just need to allege it hasn't been done in good faith that you believe. Okay, we're going to leave it at that. But that's this week's project, right, is to take some things to an attorney and say, I want you to take this to the special grand jury and bring in a copy of this law, 18 U.S.C. 3332, and maybe this one here, 18 U.S.C. 1509. And, if this doesn't get their attention, well, I don't know what to do next. I guess the next thing to do is, like it shows here, we talked about this some already. Every state has some version. I'm not going to say every state. You're going to have to find out if your state does. Let's say every state does, right? Some commission on law enforcement standards. These are the people that say, here's the procedure you need to follow to become a law enforcement agent. When you're all done and all the boxes are checked, well, now you're a law enforcement agent. You can be oathed, badged, and armed, right? And you're a peace officer, and now you can arrest with or without a warrant. Things of that nature. Full police power granted. Well, not everybody that acts like a police officer has full police powers. A conservator of the peace in Michigan would have these powers. but a special conservator of the peace in Virginia may not. It could be called the coroner, which is what it looks like it's called in Illinois. But we don't have coroners here anymore. We used to. Well, we may have medical examiners, but they're hard to find. But it isn't any of these elected offices anyways, because all the offices, when you look at if they were being elected, they weren't elected. They didn't do it properly to be in the political subdivision of the state. They may have gotten themselves elected to the corporate body politic, right? But that isn't what we elected them for as the people. They're supposed to be our representatives to the state. And they're not doing it. And this is your state representatives and mayors, councilmen, all these people. None of them are properly elected. And that shit needs to be pointed out to the, well, to the special grand jury under 18 U.S. Code 3332. Beautiful. We'll see what happens. You'll have a great day.